Distinguished heads of state and government, honorable ministers and delegates, brothers and sisters of Africa, I stand before you today compelled by conscience to address a situation that deeply troubles me, not because I seek to interfere in the internal affairs of a sovereign nation, but because the principles at stake transcend borders and speak to the very foundation of justice across our continent. I speak today about Mazi Nnamdi Kanu, whose case has become a mirror reflecting uncomfortable truths about how justice is administered in some parts of our Africa. Let me begin with the facts, because facts matter when we discuss justice. On the 13th of October 2022, the Court of Appeal in Abuja, Nigeria, issued a unanimous judgment ordering the immediate and unconditional release of Mazi Nnamdi Kanu. 3 distinguished justices examined his case and concluded that his extraordinary rendition from Kenya was illegal, that his rearrest violated both Nigerian and international law, and that the circumstances were so fundamentally flawed that they invalidated the entire proceedings against him. This was not a minor procedural observation. This was not a technicality. This was the Court of Appeal, one of Nigeria's highest judicial bodies, declaring that the foundation of the case against Kanu was built on illegality and ordering his immediate release. Yet, brothers and sisters, as I speak to you today in 2026, Mazi Nnamdi Kanu remains in detention. The court's order has been ignored. The judiciary's decision has been treated as if it were merely advisory rather than binding. A man whom the court said should be free continues to languish in prison, not because any higher court overturned that decision, but simply because the executive authorities have chosen not to comply. I ask you, what does it mean when court orders become optional? What does it say about the rule of law when judgments are obeyed only when they suit those in power? What message does it send when the executive can simply ignore the judiciary whenever a decision proves politically inconvenient? This is not a small matter. This strikes at the heart of democracy itself. The separation of powers, the independence of the judiciary from executive control, is not merely a constitutional nicety. It is the foundation upon which all our freedoms rest. When that foundation crumbles, everything built upon it collapses. But even this flagrant disregard for judicial authority is not the full extent of what troubles me. There is another dimension to this case that reveals a pattern of selective justice so glaring, so disturbing, that it demands our attention and our condemnation. While Mazi Nnamdi Kanu sits in detention for advocacy and political speech activities that, whatever one thinks of them, resulted in no loss of life. Nigeria has witnessed an entirely different standard applied to actual terrorists whose crimes are documented, whose victims are countless, whose hands are stained with innocent blood. I speak of Boko Haram terrorists who have been de-radicalized and released back into society. I speak of bandits who have massacred entire villages, who have kidnapped school children from their dormitories, who have raped women and burned communities. To ashes, these men have been amnestied, welcomed into rehabilitation programs, and in some cases even given financial support for reintegration. Let me be specific, because this is not abstract theory. In recent years, Nigeria has conducted what it calls Operation Safe Corridor, a program that has released hundreds of former Boko Haram fighters back into society after what authorities describe as rehabilitation. These are individuals who belong to an organization that has killed tens of thousands of Nigerians, that has displaced millions, that has committed atrocities that shock the world's conscience. Simultaneously, bandit commanders in northwestern Nigeria, men who have kidnapped students from schools, who have murdered travelers on highways, who have terrorized rural communities, have been welcomed to negotiations that result in cash payments and amnesty in exchange for promises to cease violence. Now, I want to be clear. I do not oppose rehabilitation and reintegration in principle. As a leader who has faced insurgency in my own country, I understand that sometimes peace requires engaging with former enemies. I understand that de-radicalization can be a tool for breaking cycles of violence. But what I cannot understand, what I cannot accept, is the profound inconsistency where actual terrorists who have murdered innocent people are offered rehabilitation, while a man whose crime consists of words, of advocacy, of political organizing, is detained indefinitely in defiance of court orders and threatened with life imprisonment. Mazi Nnamdi Kanu has never detonated a bomb. He has never kidnapped a schoolchild. He has never attacked a village or murdered travelers on a highway. His alleged offenses relate to speech, to advocacy for self-determination, to organizing protests, to demanding rights for a people who feel marginalized. These activities may be controversial. They may be uncomfortable for the government, but they are not terrorism in any meaningful sense of that word. Yet the Nigerian justice system has treated him more harshly than it treats actual terrorists. He was sentenced to life imprisonment, while confirmed killers walk free after repenting. He remains in detention while the Court of Appeal's order for his release is ignored, while bandits who surrendered their weapons are celebrated and compensated. What logic justifies this disparity? What principle of justice explains why words merit harsher punishment than murder? What standard of law makes political advocacy more criminal than actual terrorism? The answer, I fear, is that this has nothing to do with justice and everything to do with politics. Mazi Nnamdi Kanu represents a political challenge, an inconvenient voice demanding rights for a people the government would prefer remain silent. Actual terrorists, while certainly dangerous, do not represent the same kind of political threat. Their violence can be negotiated away. Their demands can be met with cash and amnesty. Their existence does not challenge the fundamental political arrangements that those in power wish to preserve. This is not justice. This is the weaponization of the legal system against political opponents, while actual criminals receive leniency. This is selective prosecution that undermines the very concept of equality before the law. And the conditions of Kanu's detention add insult to this injury. He is held in Sokoto Prison, a facility located over 700 kilometers from the Abuja court where his trial is conducted, in one of the most dangerous regions of Nigeria, a region plagued by the very terrorism that others have been amnestied for committing. Northwestern Nigeria, where Sokoto is located, has been devastated by bandit attacks, kidnappings, and terrorist incidents. Security installations have been overrun. Villages have been razed. Travelers are kidnapped regularly. The Nigerian military conducts operations there constantly because the threat is so severe. Yet here is Mazi Nnamdi Kanu, a high-profile detainee whose case has generated intense emotions across Nigeria, held in a prison facility in this volatile region. Should an attack occur, should something happen to him while in custody, the consequences would be catastrophic. The tensions that already exist would explode. Whatever possibility exists for peaceful resolution would be destroyed. Why is he held there? The distance makes his defense nearly impossible. His lawyers must travel enormous distances for consultations. His elderly mother has suffered trying to see her son, undertaking journeys that would challenge anyone in the best of health. Every court appearance requires a logistical operation spanning hundreds of kilometers. There is no legitimate reason for this arrangement. It serves no interest of justice to make a defendant's legal defense this difficult. It serves no security purpose to hold him in a region where he is exposed to terrorist threats. The only explanation is that his detention conditions have been deliberately designed to be as punitive and difficult as possible, regardless of what justice requires. I have led my country through difficult times. I have faced insurgencies and security threats. I have had to make hard decisions about how to deal with those who oppose the government or challenge its authority. But I have never forgotten that justice must be consistent, that the law must apply equally, that even those we consider opponents or enemies are entitled to basic fairness and human dignity. When I see what is happening to Mazi Nnamdi Kanu, I see a failure of these basic principles. I see a court order ignored because it is inconvenient. I see a man treated more harshly than confirmed terrorists because his political advocacy is more threatening to those in power than actual violence. I see detention conditions designed to punish and endanger rather than to serve justice. This is not the Africa we are building. This is not the future we are fighting for. We did not throw off colonial oppression and struggle for independence only to create systems where justice is selective, where courts are ignored, where political opponents are crushed while actual criminals are amnestied. To the Nigerian government, I say with all the respect due to a sovereign nation, you are setting a dangerous precedent. When you ignore your own courts, you undermine your own institutions. When you treat political speech more harshly than terrorism, you reveal that your concern is not security but control. When you hold a man in conditions that endanger his life while releasing those who have taken countless lives, you expose the emptiness of your claims to justice. The Court of Appeal ordered Kanu's release. Honor that order. Your judiciary issued it. Your executive must obey it. This is not a request for special treatment. This is a demand for basic respect for your own legal system. If there are charges that must be addressed, if there are legal proceedings that must continue, then let them continue under conditions that are fair and safe. Transfer him to a secure facility near Abuja, where his trial is conducted, or better still, to the southeast where his family can visit him and his safety can be better assured. Allow him to mount a proper defense without the enormous logistical obstacles you have placed in his way.